Maybe I can't do it.
The broadcast is now starting. All attendees are in listen-only mode.
Yeah, hi there everybody. This is Nick Bradley from the Unison Health Group, who's working today with Shantha in delivering this first legal webinar. We're just a minute early, so if you just hold on and we'll come back to you very shortly.
That's it.
Yes, hello everybody. This is Nick Bradley. I work here in the health group at Unison Centre. Alongside me I have Shantha David, who is one of our solicitors in the legal department here, and she's going to take us through this presentation. Just a couple of bits of housekeeping for you today. As you'll see and realised, everyone is on mute currently, and I will keep you on mute until we, at the end of this session, have an opportunity to ask some questions to either of us at the conclusion of the seminar. There are way too many people that are taking part today. We have 134 people that registered to take part in this, so you'll appreciate it's going to be very difficult to keep track of all the questions people want to ask. If you have got questions, you can raise your hand at the end of the seminar, but equally you can text in. There's a question message panel on the bottom of your toolbar there. You can text in some questions. We probably won't be able to answer them during the seminar now, but Shantha will do her best to answer them afterwards. So we're still having people arrive as we get underway. Like every meeting, not everyone's here on time. Also, those of you that have dialed in and are listening to this on the telephone, if you haven't entered the PIN number that you were asked to enter, and I think you'll find a reference to it on your toolbar, all that means is that when we do have an opportunity of asking questions, I can't bring you into the discussion. So please make sure if you've dialed in on the telephone that you have entered your PIN number, and I can see various people have done that. So that's the agenda we've got today, and I'm going to move straight on now and hand over to Shantha to make the presentation.
Hi everyone, I'm Shantha David. I'm a solicitor in Unison's in-house legal department. You're not going to see my face for much longer, I'm pleased to let you know. I'm just going to show you the slides on the screen. So I'm still here, but I shall be talking to you. Great, so I'm here to talk about the law relating to the transfer of undertakings or outsourcing. This legislation is known as the Transfer of Undertakings Protection of Employment Regulations 2006, and as many of you will know, this was amended last year. This session is an introductory session, and if you're interested, we hope to have a further session, an advanced session, in about 2 to 3 weeks' time, and I'll talk to you about dates at the end of the session. Just to let you know, obviously, these sessions are not an alternative to legal advice. If you're coming in from a branch, then please refer your queries to a region, who will then refer the queries on to Unison solicitors where necessary. So TUPE, let's start talking about TUPE. TUPE is derived from European Community Law in order to fulfil the UK's obligations under the Acquired Rights Directive. At its most basic level, TUPE operates to preserve an employee's contractual employment rights enjoyed before the transfer. So the regulations preserve the continuity of employment and terms and conditions of those employees who have now transferred from the old employer, who is also known as the transferor, to the new employer or the transferee. The new employer is simply meant to step into the shoes of the old employer, and the shoes might be as uncomfortable as the shoes on the screen. So what is protected? the employee's terms and conditions, their continuous employment, collective agreements, recognition, all their contractual rights, and matched pension contributions. I'm not going to talk here about pensions, and that's something that we can deal with in the advanced course. The next thing to figure out then is what is covered by TUPE. There are two types of transfer. There's a transfer of an undertaking or a service provision change. Looking first at a transfer of an undertaking, there are three vital components, and these are that there is firstly an undertaking, also known as an economic entity. There is a transfer of that undertaking, and following the transfer, that undertaking retains its identity. So let's talk about what an undertaking is. This is described in Regulation 3.2 of TUPE as an organized grouping of resources which has the objective of pursuing an economic activity, whether or not that activity is central or ancillary. So the undertaking must be an organized grouping of assets or employees which then pursues an economic activity. Now what you need to know is that TUPE may apply to the transfer of the whole or just a part of an undertaking, even if that particular part becomes an identifiable economic entity only after the transfer. The second component for a transfer of an undertaking is that there must always, and this sounds obvious, but there must always be a relevant transfer as set out in Regulation 3.1 of TUPE. So there's a transfer of an undertaking, business, or part of an undertaking or part of a business that is situated in the United Kingdom, and it has to be situated in the United Kingdom immediately before the transfer, and it must be transferred to another person. So the wording is another person. The third component is that the undertaking must retain its identity. The European Court of Justice has said that a retention of identity can be evidenced by the fact that an operation is continuing or resumed by the new employer. These principles that are set out in this slide were laid down in a case called Spikers and Gebroeders Benedict Abattoir back in 1986 in the European courts, where this test, the multifactorial test, was used, and it remains the guiding authority. However, the importance attached to each of those limbs or each of these criteria will vary according to the type of activity that's carried out by the undertaking. And a case called Vidal in the UK said that. So you would need to look at the type of undertaking. You need to look at whether or not tangible assets transfer, although there is case law to say that even where assets are owned and are required to run the undertaking, the fact that they don't transfer doesn't mean that there is no transfer of an undertaking, so that's a bit confusing. Then you look at the value of intangible assets at the time of the transfer. So you can look at whether or not the customer base was included and transferred, or funding has been transferred. You can consider whether the majority of the undertaking's employees are taken over by the new employer, although employers that deliberately avoid taking over transferred employees can't then rely on this to say, oh look, there was no transfer because the employees haven't transferred over. Then you need to consider whether or not customers have transferred. You can look at the degree of similarity between the activities carried on before and after the transfer. Although somewhat confusingly, there was a case called Sanchez Hidalgo back in 1999, which said that the fact that the service provided by the old and the new contract was similar didn't necessarily justify or come to the conclusion that there had been no transfer. And then you look to see of the period of time for which those activities were suspended. However, again, this isn't a conclusive test. And a case called Allen said that no particular importance should be attached to the gap between the end of the work by one subcontractor and the start by the successor, for example. The court took pains to point out that each of these factors is only part of the overall assessment, and that individual factors cannot therefore be considered independently of each other. However, as some of you will know, this test has had less value since such cases are likely to be considered to be service provision changes. Sorry. The definition of a service provision change came about after a lot of litigation in the UK courts and in the European courts. In short, there is a service provision change when the activities carried previously by the transferor are following the transfer carried out by a contractor, so outsourcing, or they're brought back in-house, or it's moved from one subcontractor to another subcontractor. Now, the conditions for a service provision change are that there is an organised grouping of employees situated in Great Britain which carries out activities on behalf of a particular client. The client then intends that those activities will be carried out by the transferee after the service provision change. And remember that the client must remain the same, and that's extremely important. Service provision changes wouldn't apply to a single specific event or a task of a short-term duration. So, for example, TUPE did not apply to the London Olympics. Also, the activities can't include, for example, the supply of goods for a client's use. So if there was a daily supply of bread to the transferor, that won't necessarily transfer to the transferee. As some of you will know, the government tried to remove the service provision changes from the definition of a relevant transfer because they saw this as part of the gold plating of TUPE, the TUPE regulations. However, interestingly, there was a lot of feedback from government, to government, from small businesses and also from larger businesses, which said this would cause great confusion and end up with loads more litigation. So fortunately for all of us, this didn't happen when the law changed in January 2014. This is the new regulation. There's a new regulation 5, and this requires that the activities carried out after the change in service provider must be fundamentally the same as those that were carried out by the person that ceased to carry them out, so the old employer. So this rules out changes made in historic transfers and only refers to activities carried out by the most previous employer, so the most recent transferor. This slightly narrowing of the section is unhelpful to us, but similarly we still have it, so that's probably a good thing. Let's see what's not covered by TUPE. I'm going to look first at the Henke exemptions. This was a case, a German case that went to the European Court called Henke and Gemeinde Schurke. Apologies for my German pronunciation. This is a case where there was a secretary in the mayor's office in Schurke in Germany who claimed that her contract of employment was transferred when the municipality joined with several others to form a new administrative authority. Now, the European Court of Justice disagreed. They said that the reorganization of structures of the public administration or the transfer of administrative functions between public administrative authorities does not constitute a transfer of an undertaking. They said it only related to activities involving the exercise of public authority. Even if it is assumed that these activities had aspects of an economic nature, they said they could only be ancillary. Therefore, there can be no TUPE transfer where there is an administrative reorganization of public administrative authorities or a transfer of these functions between public administrative authorities. This judicial exclusion of reorganizations of public authorities has since been adopted in Article 1.3 of the Directive and in Regulation 3.5 of TUPE. However, thankfully, it's been interpreted very strictly and narrowly. There was a case in Italy called Scatolon, which in 2011, where the ECJ held that this exception applied only to entities which were engaged in the exercise of public powers. So why do we need to know all about this? Now, I'm sure a number of you have heard of COSOP. This is the UK Cabinet Office statement issued in 2001. It's a Cabinet Office Statement of Practice, and the full title of it is Staff Transfers in the Public Sector, and it's known in short as COSOP. This emphasises the former Labour government's intention that, other than in exceptional circumstances, it expects employees transferring within or from the public sector to be protected by the TUPE principles, even if TUPE doesn't strictly apply. If necessary, this could be achieved, they say, by legislation relating to the specific transfer. Now, the first point to note is that COSOP is no sort of saving grace. TUPE is enshrined in legislation, while COSOP has no statutory basis whatsoever and no force, but represents the policy which government departments are required to follow. In fact, it only provides a guarantee and guidance, I suppose, to support effective transition and transfer between public sector bodies. And in effect, it promises to honour TUPE where TUPE doesn't otherwise apply. So if there is a relevant transfer, then TUPE will apply, obviously, as a matter of law. Where TUPE doesn't apply, so if there is such a reorganisation, the default position in the public sector is to rely on the principles of COSOP, which in effect promise to honour TUPE. How this happens is that there needs to be an enabling piece of legislation to make provision for a transfer order or scheme permitting the transfer of staff from the old to the new employer. So you can't have COSOP in some sort of vacuum. There has to be another statutory instrument or piece of legislation which allows for there to be a transfer order to permit a COSOP transfer. So, for example, under the last government, transfers of staff by means of a transfer order were made under the Greater London Authority Act 99, and this was enshrined into legislation under the Transfer of Undertakings Protection of Employment Greater London Authority Order 2000. Now, this particular statutory instrument makes clear that any transfer via the GLA which is not covered by TUPE will be deemed to be a TUPE transfer as a result of this particular transfer order. So just to recap, if TUPE applies and employees' contracts of employment are transferred by TUPE, then their terms and conditions of employment will be preserved post-transfer. Where TUPE doesn't apply, then the terms and conditions of that transfer will be dictated by a statutory instrument or regulations. Obviously, this has to relate, or this doesn't relate only to the public sector. And what you will find generally is that the terms set out in a transfer order or transfer scheme are not as good as TUPE, but possibly is subject to negotiations between the trade union side and the employers. COSOP was revised in December 2013, but remains intact. Moving on to the sorts of claims you can make under TUPE. There are two forms of claims. You have individual claims or union claims. As far as individual claims are concerned, following a transfer, an employee who isn't transferred or who is transferred but then is dismissed can bring a claim for unfair dismissal. Say, for example, following a transfer, an employee continues to be employed but their terms and conditions are changed. They can then bring a claim for breach of contract. Or say an individual's terms relating to pay are altered post-transfer, then they could bring a claim for an unlawful deduction of wages. So those are the types of individual claims that exist. Union claims are those that can only be brought by a union, so they are, for example, where the transferor or the transferee failed to provide information or they failed to consult over the TUPE transfer. Right, this is in red, so it must be important. If you take anything from this webinar, I hope you take this away. Claims must be brought within 3 months less 1 day of the dismissal following a transfer, of any pay deduction following the transfer, or 3 months less 1 day of any failure to inform and consult with the union. Remember also that when triggering early conciliation, you would need to trigger early conciliation specifically for Unison as a separate claim, and there would need to be a further early conciliation notification for individual claims such as unfair dismissal or failure to inform, deduction of wages, etc. So here's an example. This is a real example where there is a TUPE transfer involving obviously a transferor, the old employer, and the transferee, and a union with whom the transferor and transferee failed to consult with. You could easily have 4 early conciliation notifications. So they would be Unison against the transferor, which is 1, Unison against the transferee, which is 2, the individuals against the transferor, and the individuals against the transferee. Now, I've been told that ACAS would love to change this, but they don't have the correct legislation to do so. So I think the more we complain, the better it is, really. Where an employer is acting in breach of contract, claims can only be brought in the employment tribunal if the claimant is no longer employed by the employer. If the claimant is still employed, then any breach of contract claim will have to be brought in the county courts, and they must be brought within 6 years in England and Wales and 5 years in Scotland. Moving on to dismissal. Now, just looking a bit at the laws around dismissal pre or post transfer. Now, the new or old employer cannot fairly dismiss an employee if the sole or main reason for the dismissal is the transfer. However, a transfer-related dismissal may be considered fair if the sole or principal reason for the dismissal is an economic, technical, or organizational reason entailing changes in the workforce. This is known as an ETO reason in short. Remember though that even if there is an ETO reason entailing changes in the workforce, a dismissal will only be fair, even if it is permitted under TUPE, as long as the employer acted reasonably in all the circumstances in treating that reason as sufficient to justify dismissal, and the employer met the other requirements of the law on unfair dismissal, or if it's by reason of redundancy. Where the dismissal is because of a redundancy situation, the new employer will still need to ensure that that redundancy is fair. So, for example, that the selection for redundancy is fair and not based on the fact that the person is a transferred employee, which they might disguise, but it would be a matter for you to look into. Moving on to changes of location post-transfer. Regulation 7.3a of TUPE changes the expression changes in the workforce to include a change to the place where the employees are employed. As you can see, the full, I won't repeat what's written on the screen there. So what it does is now make a reference to Section 139 of the Employment Rights Act and say that if it's similar to a redundancy situation, then it's permissible. A change of location is a permissible reason to dismiss. So where the transferee no longer requires the transferred staff to carry on the transferor's business or to carry out work of a particular kind in their ordinary place of work, then such employees will be deemed to be redundant. When the EAT decided some of these issues in a case called News and Abellio, it said that such a change of location on transfer would amount to a dismissal. The employer would then need to ensure that such a dismissal was fair, so procedures were properly followed. Until January 2014 and the amendments to TUPE, it wasn't clear if the term entailing changes in the workforce included a change of location. Now, we ran a case called Bassani against NSL and R.R. Donnelly, which was decided in May last year, which considered the meaning of a change of location prior to the TUPE changes. Mrs. Justice Slade held in that case that dismissals of employees by reason of or connected with the transfer of an undertaking for refusing to change the location of their workplace are not dismissals which entail changes in the workforce within the meaning of TUPE Regulation 7.2. She said, therefore, that these dismissals, which were because of a change of location post-transfer, were automatically unfair and fell under the unfair dismissal rules. However, unfortunately, that has all changed now, and a change of location is permissible post-transfer. However, a new employer can still fall foul of this section if they change the employee's location post-transfer and don't have an ETO reason for doing so. Looking at changes to terms and conditions post-transfer now. Now, the new employer can vary terms and conditions if the changes have nothing to do with the transfer. So even harmonization is allowed if it has nothing to do with the transfer. However, where the variation is transfer related, the revised regulations allow a variation of contract if the sole or principal reason for the variation is an economic, technical or organizational reason entailing changes in the workforce, provided that the employer and the employee agree that variation. So a variation can only be agreed with the employee's consent. A variation is also permitted if the contract allows it, so the original contract allows it. However, if an employer tries to agree a term that allows them to make variations in the future following the transfer, and the sole or main purpose for that change is the transfer, then such a variation prior to the transfer or post-transfer would be void. Where a transferee attempts to harmonise the terms and conditions of transferred staff with those of the existing staff, then the transfer would be the reason for the change and in breach of TUPE. Again, you should always look at the facts of the particular situation before you can determine what exactly has happened. Collective agreements have also undergone some changes under the new TUPE regulations. An employer is permitted to seek agreement to vary terms and conditions incorporated from a collective agreement a year after the transfer. This variation may only take place with the agreement of the individual employee, note the individual employees and not the union, and so they need the agreement, and if the terms overall are no less favourable than the current terms. So this means that some terms can be less favourable as long as some are more favourable, and considered altogether the previous terms and conditions and the current terms and conditions balance out. Obviously, this is going to be a very difficult, if not impossible, exercise in practice. And for those of you who did equal pay law, you might think this is going to be an absolute nightmare, and I would agree. Along with the practical difficulties, this will also create a two-tier system of contractual rights. So those terms and conditions that arise out of an individual contract of employment will have greater protection from variation under TUPE than those that come or that are derived from collective agreements. So a year from the transfer, the new employer can amend collective terms and conditions, whether or not it is because of the transfer, and even if there's no ETO reason entailing changes in the workforce. However, individual terms and conditions, so those not derived from collective agreements, can only be changed if it has nothing to do with the transfer and if there is an ETO reason entailing changes in the workforce. I suspect this will be challenged at some point in the future, and we'll update you in due course. Now, the renegotiation of collectively agreed terms and conditions will involve the making of an offer to give up collectively bargained terms and conditions, which the European Court of Human Rights decided in a case called Wilson, Palmer, Doolan and against the UK to infringe Article 11 of the European Convention on Human Rights, which protects the right to freedom of assembly and association. In July 2014, an employment tribunal in Bromley considered such a claim that Unison brought, where the London Borough of Bromley made offers to Unison members that gave effect to a 2012 council decision to withdraw from national and regional pay bargaining. They wanted to control the pay setting process completely and were expressly unhappy with the delays encountered in the NJC collective bargaining process. So the series of offers made by Bromley asked employees to vary their employment contracts and agree to a localised pay setting process which replaced national and regional collective agreements with future pay awards determined solely by the full council. Most of the employees agreed. However, this case was brought by a number of Unison members who did not and who were ultimately dismissed and re-engaged on new terms of employment that included the localised pay setting process. At the hearing, the Council conceded everything in this case except the issue of whether or not the offers were made for the prohibited purpose, that is, to get out of collective bargaining. Now, the ET found in our favour. They held that the Council had made a series of similar offers, the effect of which was for the prohibited purpose that the claimant's terms and conditions of employment, in particular pay, were no longer to be determined by collective agreement. And because this is the type of claim where employees simply, the tribunal awards a penalty payment, it awarded each of the claimants compensation of £3,600 for breaches of Section 145B. Now, the ET also found that the offers were made for the prohibited purpose on both the narrow purpose, that's the objective interpretation of the letters sent to staff, and the wider purpose, the underlying reasons for the council decision. And the ET found that although the purposes have been expressed in a number of different ways, the real purpose to withdraw from collective agreements was manifestly clear from all of the evidence and the documentation. Again, these sorts of claims are so fact-specific that it is important to try and understand what the purpose, and this is sometimes that requires you to go into the purpose of the employer's mind, which is difficult. You need to find the real purpose of why the council here made the decision. So it remains to be seen that in future, if transferees will seek to renegotiate collectively agreed terms and conditions, and whether these will be contrary to Section 145B of the Trade Union and Labour Relations Act. Please note that Section 145B is engaged on the making of any offer to give up collectively bargained terms and conditions. So an employer doesn't have to offer any kind of sweetener or inducement of money or anything else, even though there's a pot of money in my slide. They just have to make an offer to get out of collective bargaining. On a separate note, the TUPE guidance points out that changes which are entirely positive from an employee's perspective are permitted, and presumably not one we would challenge in any event. The new regulation 4A of TUPE provides that transferred contracts don't bind the transferee to any term of a collective agreement agreed after the date of transfer if the transferee is not a participant in the collective bargaining machinery. Now that is the result of a case called Alameheran and Parkwood that we ran for at Unison for 7 years. So what this case says, and what the legislation now says, is that it provides for a static approach to the transfer of terms derived from collective agreements. So basically, you go over and you go with whatever your terms and conditions are, and those cannot change. So, for example, if an employee's pay is set at £8.50 an hour on the date of transfer from the transferor, any increase negotiated by the transferor following the transfer to say £8.75 would not apply to the transferred employees. However, those pay increases would apply if the transferee participated in the pay negotiations. The practical outcome of all of this is that following a transfer, those that transferred under TUPE will be stuck with that rate of pay, while others around them may be getting pay rises, which is obviously not ideal. So I have a quick question and see if I haven't lost all of you, hopefully. And it's this, and it should be on your screens. If you renegotiate pay post-transfer with the new employer, do you lose all your other TUPE transferred terms and conditions? You're all putting in your answers now. Right, so 93% of you think no, and 7% of you think yes. I'm very pleased to say that the majority is correct. You don't lose your other terms and conditions. And I'm very pleased that most of you got that right. Moving on then to pre-transfer consultation on redundancies. Right, I'm just going to move that on. So where a transferee proposes to make 20 or more staff redundant, that will affect some or all of the transferring employees, and the transferee may elect to consult in relation to those redundancies prior to the transfer. However, before pre-transfer consultation can take place, the transferee has to seek agreement with the transferor, and you will see that the election has to be made in writing to that transferor. The effect of this is that the new employer, the transferee, can consult on post-transfer redundancies with the trade union recognised by the transferor, so the old employer. Arguably, this section doesn't comply with a piece of European legislation called the Collective Redundancies Directive, which only obliges the current employer to inform and consult and not a future employer. Also, I mean, the motivations to inform and consult under Section 188, which is the section to avoid redundancies, and Regulation 13, that's to do with TUPE transfers, are very, very different. Section 188 of TULRCA seeks to avoid dismissals and contains mandatory obligations for the purposes of collective redundancy under the Collective Redundancies Directive, as I mentioned, while Regulation 13 requires information in relation to the transfer of staff and any measures which the old or new employer will take as a result of the transfer, as prescribed by another piece of European legislation, the Acquired Rights Directive. Now, one particular point to note concerns the relationship between the transferee and the transferor employers in this rather artificial situation. Section 198A, capital A 4B, states that the transferor may provide information or other assistance to the transferee to help the transferee meet the requirements of this chapter. But the thing is, they don't have to. And depending on whether they see eye to eye, they might not assist. Section 198B, capital B1D, says that a failure on the part of the transferor to provide information or other assistance to the transferee is not to constitute special circumstances, rendering it not reasonably practicable for the transferee to comply with the consultation requirements. So the transferee can't even say, well, I have a defence here under section 1887 of TUPE that I wasn't provided this information, if they just have no defence. So the transferee may not want to actually take part in these early redundancy negotiations prior to the transfer. The transferee may choose to cancel or elect to carry out pre-transfer consultation, but once it's cancelled, it cannot later be revived. The pre-transfer consultation should continue after the transfer if it hasn't been concluded, and it may continue with the same representatives, that's the transferor's representatives, which might be tricky if the transferee doesn't recognise them, but might also be an opportunity to ask the transferee to recognise them. However, any notice of redundancy can only take place after the transfer and not before it. This is because the transferee will not be the employee's employer until after the transfer. Right, we're almost there, folks. I'm going to talk to you about agency workers. Following the changes to Section 188 of TULRUCA and Regulation 13 of TUPE, brought in by the Agency Workers Regulations, and in the first case of its kind, the Employment Tribunal in Watford ruled in April 2013 that Barnet Council had failed in very many ways, but also it failed to provide Unison with information on the number of agency workers it employed. Now, Unison asked for this information to protect permanent council employees who were about to be made redundant or who were about to transfer to new employers. The tribunal, as I said, found in Unison's favour and made protective awards of 60 days, 40 days and 50 days of gross pay in respect of the two relevant transfers that had taken place and the redundancy exercise that took place in 2012. Now, in calculating the periods for which those awards should be made, the ET said that because there had been some consultation, but it took as a starting point the maximum that is available in law and then worked downwards from there. Bearing in mind, of course, that you can get a maximum of 13 weeks in these situations per transfer or per redundancy exercise. Now, Barnet Council appealed, and in December 2013, the EAT held that the tribunal had misdirected itself because the starting point of the maximum was only to be used when the employer had not engaged in any consultation at all. Now, those weren't the circumstances of the present case, and therefore the case was to be remitted to the same tribunal to consider the amount of the award, not the decision, just the award. However, before this went in front of an ET, the parties settled the claim and got 85% of the value of the awards made at tribunal. So it was a pretty hefty award that Barnet were lumbered with. They had to pay, I can't remember the numbers, 85% of 60 days, 40 days and 50 days of gross pay. Finishing off very quickly of the other changes that were made by the TUPE regulations last year, you may wish to know that micro businesses which employ less than 10 staff may inform and consult employees directly when there is no existing trade union or employee representative. So the key is if there is a trade union, they have to consult with a trade union. Also, less relevant for us, but the deadline for the old employer to supply employee liability information to the new employer has increased from 14 to 28 days before the transfer. So there you are. That was a speed tour of the TUPE legislation. I hope that you found it useful, and I think there are some questions in front of me.
If I take, yeah, one person, Helen Stokes, thank you, Helen, has posed a question, and I'll read it out. A local government contract is let for 1 year. At the end of that time, the contract is re-let, similar to the original contract. Does TUPE apply to the original contract staff, and are there contract time limits?
If there's a transfer from one employer to the other employer, as long as there is a transfer of an undertaking, then yes, TUPE should apply.
Okay, thank you, Shanta. Sam Alders just asked a question that it says the session's being recorded, which it is. Where will this be held, and will it be available for other staff or reps to listen to? The answer to that is yes, it will be, Sam. We'll send you out afterwards a web link that you will be able to share with your colleagues in the office there. And from Monica, brilliant presentation, well done, thank you.
Thank you.
And thank you for that comment. And from Sam, thank you. So do we have any other questions anyone has got that they want to pose? Feel free to put your hand up if you want to be brought in to ask the question verbally. I feel like an auctioneer here. In a few seconds I'm going to close it, but if we don't have any other questions that you want to pose, yeah, thank you, Sam. If you don't have any other questions you want to pose, Shanta and I have just got a couple of questions to put to you now. The first one is, have you found this webinar useful? It would just be useful to get from you a response on that. So I've just opened a quick poll. Most people are still voting. So we'll just wait for you to cast your votes in this. While we're waiting for that, I've just had a question from Manjit. She said, can we have the slides? We'll put the slides up in the same site that we put the recording up, so you can get hold of the slides as well. Okay, most people have voted. I'll just put that on the screen for you so you can see. 91% of you voted yes, and 9% said no. So thank you to that. Right, another quick question there from Sophia. Do you think the GE result have an impact on TUPE?
Yes, if Labour win, they have promised to get rid of the new TUPE amendments, which will be a great thing. And we have to make sure that they stick to their promises.
Lots of ifs in there. Jamie, a question from you. Unless a new employer states otherwise, do the policies of the old employer still stand, even if it's 15 years later?
I would say that that would depend on whether or not the policies are contractual policies or whether they are non-contractual policies. If they're contractual policies, then they would automatically bind the new employer. If they're non-contractual ones, then they won't. But 15 years is a long time. I mean, it depends what custom and practice has taken place since then as well.
Okay, and I've got a question here from Robert, and he's apologised because he's got lots of capitals in his typing here. Is there a unison dispute about whether TUPE applies to transfer to DWP after universal benefit is applied?
TUPE applies to... I'm not sure I understand the question.
Yeah, I'm not sure I understand it either, Robert. Do you want to try the question again?
Should have put down... Oh, there's a hand up.
Robert, I've just opened your microphone. If you're able to pose the question verbally, we'll take it verbally.
Can you hear me now?
Yes.
Lovely, thank you. Yes, I understand that a lot of the revenues and benefits work is going to move over to be done by Department of Work and Pensions, mainly through the Job Centre Plus. This is after the universal benefit comes in. Obviously, lots and lots of benefit calculations are cancelled. There's this single one, and regions seem to be saying that TUPE will not apply because the work is fundamentally different. The work has in effect evaporated, I think is what they're saying, evaporated due to the change in the work, so it's not a TUPE matter when it goes to DWP.
I think it's such a highly factual question. I think if they're saying that the work has changed, has been a fundamental change in the work, it will be down to us to show whether or not that is true or not. So if any employees have lost their jobs as a result, then we should consider cases and consider whether or not they've lost their lost their job because apparently the employer says there's no job for them, but the job remains the same. So I would suggest that that's sort of one that needs to be referred to us so that we can have a look.
Okay, thank you. Andy Faulkner, you've got your hand up. I'll just unmute you so you can pose your question.
Thanks for that. I was having trouble typing then. Yeah, if well, I'm being transferred over to a social enterprise from local government, and they're going to recognise the NJC pay bargaining and whatever's agreed there comes to us. But will we be entitled to take industrial action if because we're being requested by Unison now, isn't it? There's something that all people affected by pay bargaining should be balloted and on this. So would that affect us if we were to, if there was industrial action, and would we be able to come out or not?
So if the new employer has said that they will be following NJC pay, and so that's in effect an agreement that they've made with the employees, then they become an employer that should be subject to those to NJC. So if they don't then go ahead and pay NJC increases, then yes, they would be affected. Is that what you mean?
No. Well, that's part of it, but the other part is if we're being balloted on pay, will we be balloted on pay because we're no longer part of local government, or I don't know, will we be balloted? Because you
probably will be balloted because the new employer said yes, we will follow NJC, and if they then turn around and don't follow NJC or don't agree, or if you say yes, we want this pay increase, if they might turn around to you and say yes, we'll give you the pay increase. So it's worth negotiating and seeing if they will. But if they don't, then because they're waiting to see what happens generally nationally, then yes, you can join you can be balloted and join the action.
Even though they're not part of the people that are actually
setting it. No, but they said they will follow it. So they've promised to the employees that they will follow NJC. So technically, they could be balloted.
Yes, Andy, I mean, I can answer that as well. In both the local government and health pay disputes we've had in the last 12 months, in both of those disputes, regions identified people employed by organisations other than local authorities and NHS trusts where staff had been TUPE transferred across and where their contracts meant that they remained on those national terms. Decisions were made as to whether or not to ballot the staff in those employers. So if for example, we had 50 people working for an employer and there was only one person still on those original national terms and conditions, a decision probably would have been made not to include them in the ballot. But where there were large numbers of members working for private companies or other organisations and people still had in their contracts those original terms and conditions, then yes, both in the local government dispute and in the health pay dispute, they've been balloted in both those examples.
Okay, thank you for that. Thanks.
Thank you, Andy. Okay.
I see another question about whether recognition agreements transfer under TUPE, and they do transfer. That's Sonia's question, but the new employer can turn around and give notice on the recognition agreement, which is something that they can do, unfortunately. And then there's another recognition question from Lynn. This says, does this have to be written into a TUPE contract explicitly? If there is a recognition agreement between the old employer and the union, then that will just transfer. And then Lynn also asks, if the new employer does not recognise Unison but does recognise another trade union, will that suffice, or can we argue that we should be recognised? Well, we can argue, but they can turn around and say no if they've already got a recognised trade union that has an established relationship with them, which again is not satisfactory.
Okay, I've got another question here.
Nami.
From Nani.
Hello?
Namada, I've just unmuted you to pose your question. I'm sorry we can't hear you, so I'm just going to put you on mute again. Apologies for that. If you want to just text in your question, we'll try and answer that before we finish. I'm just double checking. I think that's it for people that had their hands up to ask questions.
So we just want to check if people are interested in the advanced TUPE course,
Okay.
and we've got a couple of dates for that.
Right, just before we come to that, Shantha, we've got, did I hear correctly that an employee can agree to a change in their terms and conditions on transfer, even if it's because of the transfer?
No, I think this was to do with collectively agreed terms and conditions and changes after a year, and that's it. In those circumstances, they can change. They can agree to a change, even if it's to do with the transfer. Does that? Yeah, I hope that's clear, Simon. The issue there is, obviously, no one is going to challenge a positive change to their terms and conditions. Most people tend to obviously challenge a negative change, but it's these new changes that have been brought into place to do with collectively agreed terms and conditions being that you can change them, which is very different to the previous law on TUPE.
Okay, thank you. We don't seem to have any other questions, so we've got a couple for you. First one, we just want to ask you, have you found this webinar format useful?
Sorry, the silence while we wait.
We're just looking for the numbers of people participating so far. So while I just let you know, 83% of people who are here today have voted.
I suppose please feel free to send us feedback by email as well. That would be quite helpful.
Yeah, you will. Everyone will receive at the conclusion of this an email saying, "Do you want to send in some feedback?" So I'll just quickly give you the answer to that. Of those of you that voted just now, 96% said yes, 4% said no. So thank you very much for that. It's very useful.
Thank you. Yes.
We've got one final question to put to you, and that is that we've got two options for part two. Now, part two will also be recorded, so if you're unable to participate, you will be able to see it afterwards. But we've got two possible dates. So if I just put those two dates on the screen, and we'll simply go by those of you that vote what is the most preferred date of the two. So that's the 23rd of March or the 27th of March.
Thank you, folks, for some of your positive feedback as well. Okay, I've got you there on the screen. This is good. It's quite interesting, the poll, because it keeps moving from one date to the other at the moment.
It does, yeah.
Okay, 67% has voted so far, so
we'll just hold on for this poll result, and Shant and I will go by whatever the majority is and run it on that date. So apologies for those of you that can't do one of those two dates.
I suspect some of you are having to check your diaries, which is why.
Yeah.
You're almost there.
We're up to 3/4 of you having taken part so far.
Seems to be a little stop. Maybe people are checking their diary.
Everyone's got their Blackberries out and they're quickly whizzing through to see whether they can do it or not. Okay, I think we've got a majority verdict actually. Since 81% have voted and 65% of you have said something, that's always going to be the majority, isn't it?
Yeah.
So I'm just going to close the poll there and share the results with you. We've got 65% of you have said go with the 23rd of March, 35% 27th of March. So we'll go and run the next one at the same time on the 23rd of March.
We'll send out an invitation and a reminder as well for anyone else who wants to join. And don't forget, it'll be recorded anyway.
Okay, well I think I'm just going to say thank you very much.
Thank you.
From us both for taking part today. Glad that you found it useful and hopefully enjoyed it, and we'll send you an email with the link to the recording. So thank you very much, and I'm going to close the webinar now.
Bye-bye.